Good afternoon. It's 11:30 and want to get started. Be sensitive to everyone's time commitment. I'm Grant Swartzwelder, President of OTA Compression and Chemark System. On behalf of those companies, we welcome you to our webinar series. This is the fourth one that we've had. The first three included environmental issues in a low price environment, facilities issues in a low price environment, and then how to handle PPP forgiveness. As you can tell, not all of those are related to what OTA and Chemark does, and what we're trying to do by hosting these events is to help the industry with information so that they can better guide their business. This webinar today is fitting for that. We have John Mitchell with Akerman. He is a bankruptcy attorney. As you saw by the invitation, we want to talk about issues of bankruptcy for your customer. What if your customer is going bankrupt? What if your vendor is going bankrupt? We're going to focus on those initially, and if we have time at the end, we'll also talk about if your company is also thinking about having those issues. But I know everyone's going to be affected by a customer or a vendor going potentially bankrupt. So we'll focus on that in our 30 minutes, and if we have time, we'll grow into that other area. Today, we're very happy to have John Mitchell. I've known him quite some time. Our kids have gone to school. He's a partner with Akerman, which is a international law firm. He's head of their bankruptcy practice. Before that, had worked for Vincent & Elkins for 13, 14 years, John. So all together has 25 plus years of experience in bankruptcy, focused in Texas, focused on a lot of energy related service, midstream, and E&P. So I think he comes very well prepared to give some input to you to maybe think about and how to conduct your business. John, welcome. And let me start off with an initial kind of just a table sitting question about what you're seeing in the industry today from bankruptcy standpoint. What are you seeing as far as filings and activity level?
Sure, thanks, Grant, and good morning, everybody, and glad to be here and appreciate the opportunity to speak with everybody. So as you can imagine, we are seeing a lot of activity, but probably perhaps not as much as I expect in the near future, say in the next 3 or 4 months. As you've been reading about in the paper, an awful lot on the retail and restaurant side. We'll get to oil and gas in a second. But a lot of retailers filing, a lot of restaurants filing. And this is the COVID-19 crisis essentially accelerated what was already a problem for big box retailers as well as for, say, casual dining and other dying concepts in the restaurant industry. So a lot of these companies sought Chapter 11 relief when essentially their cash flow stopped. People quit eating out, people quit going and shopping, and in they went. You've seen some of the larger ones hit the papers: JCPenney, Neiman Marcus, Pier 1, and some others. But what they're doing is they're just camping out because nobody's spending money. And they're waiting until the economy starts to recover before they really begin to restructure their affairs. What this has caused is a realization among landlords and creditors and lenders that if I push too hard right now, they're just going to end up going into bankruptcy and seeking the relief of the court. And even if I do evict a tenant that's not paying me, who am I going to re-let the property to? Or if I force a store to go out of business, who am I going to sell the inventory to? So what's happening is a lot of landlords, a lot of lenders are working with troubled borrowers just for short-term, to give some short-term relief until this economy starts to turn around a little bit here in the near future. But where we think we'll see a lot of the restructuring is when we decide what our new normal looks like. Eating out habits may change, shopping habits may change, a lot more may move to online. And so a lot of companies are going to need to be restructured in the near future. Oil and gas, again, I think COVID-19 just exacerbated already a problem we had. A lot of deleveraging from the 2014, 2015 downturn in oil and gas prices. A lot of short-term debt was put on a lot of companies that was coming due in 2020, 2021. We were expecting a lot of restructuring activity. Add in the Saudi war with the Russians and then COVID-19, and we see a lot of E&P companies jumping in to bankruptcy. The most part, they're de-levering. They are working with reworking contracts, reworking trade relationships, but for the most part, they're de-levering their funded debt, first lien debt, second lien bond debt. They're really reworking that, equitizing a lot of it, de-levering the company, and trying to emerge leaner with less of a debt load on them.
Very good. It's again, focus being more on the customer. I wanted to kind of hone in on that. And we all have customers that are starting to have credit issues. We're worrying about payments. What do we need to do to kind of be prepared? Well, there's kind of a series of steps. Should we be worried about them? Why? Then what do we do about those worries?
Yeah, a lot of my clients have reached out to me, and they're taking a holistic approach and to really looking at all of their customers from a credit perspective. So I would say, yes, in this environment, you should actually be going through your customer list from really A to Z and evaluating the credit risk for each and every one of those. I think that's a smart move at this point, and we're working with a lot of credit departments within our client base, analyze what they can do to shore up their credit assurances. So look at your credit assurances and what type of credit assurance you might be able to ask for, either contractually or even if you don't have it in your contract, go ahead and ask for it anyway, and ask for a modification to your contractual relationship. What can some of that?
You're saying credit assurance or insurance?
Assurance, not
Assurance.
Insurance. Now,
And then
some of it.
Explain that
credit,
to me.
You bet. So credit assurance is just a common term that a lot of credit managers use in looking at bolstering credit with a customer. So, for example, it's kind of a general term for, say, do you have a letter of credit for some amount that you could draw upon should there be a default or should there be a non-payment situation or a bankruptcy? That could also include performance bonds. It could include deposits. It could include prepays, or even a guarantee from a third party, say a principal or perhaps a more solvent member of the affiliation of companies that make up your customer. Letter of credits are best because it's a direct contract between you and the borrower's bank, and you can draw on it at any time so long as the condition of the draw is met. But what we're seeing a lot in the industry, in the oil and gas industry, is a move away from letters of credit and toward performance bonds. It's an insurance product. It's a little bit cheaper for the borrower, and it still gives you generally the same type of credit coverage. A little harder to draw on a performance bond. It's not as easy as an LOC, but we're seeing an awful lot of that. So you might want to take a look at what credit assurances you have with your customer and how you might be able to get additional security in the form of a deposit, letter of credit, performance bond, or guarantee.
Now, that all sounds great for a big company or big midstream and all, but I know on behalf of my little company and probably several of our attendees, the chance of them getting a letter of credit or performance, it's not likely. Well, I'd even say it's not going to happen. So if you're kind of stuck with that relationship that you've extended them credit, take us from that point of us poor small company perspective.
Sure. So there may not be a lot you can do on the credit assurance side, but one thing you can do is go to school and understand. You may need legal counsel on this, you may not, but go to school and understand what your lien rights might be. If you do have a contractual relationship with the company, you may have lien rights given to you by contract, by agreement with the party. We hereby grant you a lien in XYZ collateral to secure performance and non-payment. Again, maybe a smaller company, you might not have that in your contract. But if you're in an oil and gas state, then often, and you're performing work for the benefit of a mineral estate, say an E&P company, you may have statutory lien rights that are available to you under the applicable state code. It varies by state to state, but the oil and gas states generally grant mineral lien rights to many of the contractors and M&M contractors working on the production. So go to school on that and see if you do have lien rights. Alternatively, you may have other rights granted to you by statute if, say, you're a common carrier. You're transporting either by truck, by pipeline, and often carriers are granted lien rights in the product that they are transporting. Make sure that you go to school on that, and understand what your lien rights are there. And then additionally, if you are performing mechanic type work, there are mechanics and materialman's liens that are granted to companies that actually have the possession of another party of their goods. And if you do improve and there are unpaid charges, and you did make an improvement, no different than a mechanic that works on your car, that mechanic has a statutory lien against the product in the mechanic's possession. And make sure you understand those rights as well. Sometimes in order to perfect and enforce these lien rights, you must take certain steps to file notice of your assertion of the lien right in either the county records office or sometimes the Secretary of State, where the work has been performed, or otherwise where the company may be headquartered or incorporated. So go to school on your lien rights and understand those, and that might be able to help you a little bit as well if you can't get the other credit assurances, and make sure that you're properly protected if you can.
So to do that, to give notice, is that something you have to have an attorney for, or is, we love you, John, but we don't always want to spend money with lawyers. So is that something that we can get a form and do all this ourselves, or at what point do we need legal counsel on that?
It is a very tricky process when you give notice. And if the notice isn't properly given, then yes, that could impair your ability to assert a lien against a distressed company's assets. Or otherwise, if it's not done properly, whereas the statute may have given you what we call a priming lien, a first lien priority, even over, say, that company's working capital lender that has a first lien bank debt. That if you don't do it right, then you could lose that first priority position, or you could lose your lien rights altogether. So I do think it is important to consult counsel on this. Often what we're doing with our clients is, the client is investing, if it's not that complicated, if the client is investing, what they'll do is they'll invest with us, say, to teach them on how to do it themselves. It's not that difficult. Let's make sure, help them develop the forms, tell them how to file, where to file, and then we kind of turn them loose, and unless they run into something a little more complicated or complex. So we also work with our clients a lot that way as well, get them kind of educated on how to do it, and then they move forward without us.
So basically let you do the first one and then we plagiarize it thereafter.
There you go. You can do that and not practice law, but I didn't say that, and don't record that part.
Well,
but you are doing it at risk. And by the way, there's an awful lot of very good attorneys that aren't necessarily with very large law firms and who do this for a living. And, a lot of people can give referrals to them and have very low overhead. And I do think that the cost is worth the benefit.
So talk about timing on this, because don't you have to have the lien, and is it lien or lien?
You can say it either way, lien or lien, either one works.
Okay,
I'm sorry, I should say lien. Go ahead.
Okay. Well, it's, but you have to have that filed before they do bankruptcy, don't you? How's that work?
Actually, no. It's better if you do have it filed before they have bankruptcy. There is a provision in the Bankruptcy Code which gives you a short period of time after they file bankruptcy in order to perfect pre-petition lien rights. But it's governed by both state law, the applicable state law, and when you have to perfect your lien against the company's assets. But then you do have a short period of time if you did do work pre-petition and you're still within your statutory period under state law in order to perfect your lien, then you do have a short period of time under the Bankruptcy Code post-petition in order to perfect that lien. But it's a very short period of time, and deadlines run very, very fast in bankruptcy. So if possible, and you have the ability to go ahead and perfect your lien right now, I would certainly advise that you do that.
Because that's always such a fine line, because obviously as a service provider, if we file a lien on a customer, that tends to really make the relationship go sideways. But at the same time, I want to get paid. So how you time that, and I also want to get the cash. So it makes it very tricky to.
It is. And we have these discussions a lot, and I certainly wouldn't do it without giving some ahead notice to your customer. Hey, look, you're behind, you haven't paid me, I've sent you, late notices, whatever it may be. Pick up the phone and call them and have a dialogue with them and say, you've left me no choice. I'm going to do this. I do understand that may cause them some headaches in their current existing credit relationships with their working capital lenders, but you've got to look out for yourself and protect yourself.
Let me also point out that there's a question button or a chat button. If you have a question, don't hesitate to send that to us and we'll incorporate that into the conversation. So just be aware of that. I have a person with a hand raised, and given that I'm not a Zoom expert, I don't know what that means. So if you have a question, write that in and we'll get John to answer it. All right, so John, walk us through now they've actually filed bankruptcy. What should I do then?
So if they file bankruptcy, so two things. One, what type of bankruptcy did they file? If they filed, you will probably be dealing with either Chapter 7 or Chapter 11. If they filed Chapter 7, that's a liquidation. The company's gone out of business. Everybody is likely fired. A trustee gets appointed, and the trustee will liquidate assets and then make a distribution for the creditors. Not much you can do other than file your proof of claim. If you believe you have a secured claim, file your secured claim. If it's unsecured, file your unsecured claim. Perhaps pick up the phone and call the trustee or the trustee's counsel and see what there might be by way of a potential recovery for you in the Chapter 7. But that's a liquidation. Chapter 11 is a reorganization, and that might be what you're dealing with more often than a Chapter 7. Now, you can liquidate in an orderly basis under a Chapter 11, but for the most part, it's a reorganization. In a Chapter 11, I think a lot of what we see are creditors that just file a proof of claim and say, well, I'm just going to sit back and see if I get paid. I wouldn't recommend that. Often, the squeaky wheel gets the grease in Chapter 11 when you're a creditor. It's funny that it works that way, but it often does. So be vocal. What you don't want to do is violate something called the automatic stay. When a company files bankruptcy, there's an automatic federal injunction that says creditors cannot, outside of the bankruptcy court or through the debtor's counsel, make demands, enforce rights, sue, try to collect, take collection remedies, things of this nature. So you've got to go through the bankruptcy process, but be vocal. Pick up the phone, call the debtor's attorney, call your contacts at the debtor and say, hey, what's going on? When am I going to get paid? Am I going to get paid? And continue to pester because often the creditors that are more vocal seem to get paid earlier in the Chapter 11 process.
And so when you're saying be vocal, is that with, again, you kind of said it, so, but I want to just be clear. Is that with, it sounds like everyone or just with the company itself or with the
company? With the company. I wouldn't be, working the phones with, say, their lender or anything like that. I would be vocal with the company.
What about the trustee or those, the court people?
Well, so no, I wouldn't. You see a lot of people sending letters to the judges that will do you no good. I wouldn't do that. And in Chapter 11, there is no trustee except in rare circumstances. So the C-suite that you've been dealing with at the company or the management that you've been dealing with at the company still remains in control of their company. It's called a debtor in possession. You're going to hear that term a lot in bankruptcy. So there's no trustee. So whoever your normal contact is at the company, I would continue to engage that normal, whoever your relationship counterparty is at the company, continue to engage and ask a lot of questions. And like I said, be vocal. Now, what can you do? Again, you cannot violate the automatic stay. You can't enforce your claim. But if you don't have a contract, if you are a seller of goods, let's just say, or you provide a service on an as-needed basis, but there's no actual contract where you're locked in to provide goods or services, then you have no obligation to continue to work with that debtor in bankruptcy. And so you need to do a little bit of an evaluation. How critical am I to this debtor? If this debtor still wants to operate, are my goods or services critical to that debtor, and what would be the transition cost for that debtor to replace me? And if that's the case, you actually have a lot of leverage on that debtor if it is going to be expensive or impossible to replace you. And so let's just say you go into the case, the debtor files bankruptcy and they owe you $25,000. If it's going to cost a lot more to replace you, then the debtor can deem you something called a critical trade vendor. And actually, if it can get court permission to pay you your $25,000 or some amount of that on your pre-petition claim, if you'll agree to provide services post-petition. And you'll be paid for those post-petition services for the most part as well. A debtor doesn't have to pay its pre-petition claims immediately. It has to be done through a plan or otherwise, but it must pay its obligations as they come due post-petition. Otherwise, it can't continue in Chapter 11. So you might be in a position where you can say, look, I'm not going to do business with you unless you pay me some amount of my pre-petition claim. If you do, and maybe all of it, I'll do business with you post-petition. They usually want terms to help cash flow. That's fine. But understand what your leverage is over that debtor. Additionally, sometimes the disruption of so many trade vendors or other contract counterparties or counterparties that can assert liens, like we talked about, over the lender's assets, can be so disruptive to the Chapter 11 process. A debtor will go in early in the case, very early, day or two or three into the case, and ask the court for extraordinary relief to say, anybody that could be an M&M lien holder, anybody that can assert a common carrier's lien or possessory lien, or otherwise just these trade vendors that are critical to me, I want to pay them all in full in the ordinary course, just in the ordinary courses. All their debts just pass through. We're seeing an awful lot of that when the oil and gas company, the E&P company, merely wants to use Chapter 11 to restructure its funded debt and leave its operating debt alone. And so be vocal. Am I a critical vendor? Why am I not a critical vendor? Why can't you have me designated as a critical vendor? Because I may take my services elsewhere. If you're a party to the contract, you're bound to continue to work under that contract during the Chapter 11 case until the debtor decides what to do with your contract. But if not, I would be very vocal and see what your options are and what your leverage might be.
Two other things on if a customer goes, and then I want to flip it to the vendor side. The
Sure.
Creditor Committee, I hear about that, but do every bankruptcy have that, or that's just Chapter 7? Explain Creditor Committee and who should worry about that and what they should do with it.
So Creditors Committee is anytime a debtor, other than a very small debtor with less than $8 million in debt, files Chapter 11, there is a federal agency, the United States trustee, different than the regular trustees, that must attempt to form a Creditors Committee. The Creditors Committee's job is to have a committee of 3 or 5 or 7 trade creditors whose job it is to weigh in on any issue into the case and to negotiate on behalf of all of the unsecured creditors for as best a return as possible, maximize the return to the unsecured creditors. The idea is nobody's going to invest in lawyers to go chase a $500 claim, a $2,000 claim, or otherwise. Legal fees chew it up. So the code says we're going to form this committee, and this committee of creditors can hire counsel, but the great thing is to represent the committee, but the great thing is those lawyers or other advisors' fees that represent the committee that appear in the case that argue and advocate on behalf of the unsecured creditors, actually their fees have to be paid by the debtor. It's a cost of doing business. If the debtor is going to go in and discharge debts, well, the way the code is written, the debtor needs to pay for somebody to kind of look out for the little guy, if you want to look at it that way. Now, there's a lot of large creditors that sit on committees. So you may be contacted by the United States trustee. Do you want to sit on the committee? Or alternatively, even if you're not contacted, you can send a letter to the United States trustee and say, I would like to sit on the committee. Do it early because it happens early in a case. But what that does is it gives you a front row seat to the restructuring, access to a lot of information and competent counsel, but you do take on a fiduciary duty like a board of directors for the general benefit of all unsecured creditors. Don't worry, you're exculpated from liability, and unless you do something horrible, committee members never get sued. But it's a good way to have a front seat and a say in the restructuring. You can't work to your own personal benefit, but I would encourage people that are interested to seek appointment to a creditors committee.
That makes sense. Let's flip over on the vendors. I'm sorry, do you have something?
No, go ahead.
Let's flip over on the vendor side. Say we're an operating company or oil company and we have a vendor that goes bankrupt. How do we handle that vendor, or what's the nuance of that, or is everything we talked about the same?
It's pretty much, it's pretty much saying that the problem is this is a vendor to you that's then gone bankrupt. And so then the question is what is the relationship between you and the vendor? If that vendor is let's just say a provider of goods, or services, but where I see it more importantly is a provider of goods or a sale of equipment or whatever it might be. You really need to start looking at cash in advance, COD, cash on delivery types of arrangements if you're worried about them going in. Because what you don't want to do is have to pay twice for something. If there's critical equipment, critical supply, whatever it may be that's being provided to you, and you're prepaying them in some form or fashion, then without having had receipt of that, then that's where you run into a problem. Alternatively, you also want to make sure that you're protected if you're doing business with a vendor that goes into Chapter 11, and that the debtor does have the liquidity in order to actually perform for you, because they're going to be liquidity constrained if they go into Chapter 11, and you may want to be thinking about alternative sources and sourcing for the product that they otherwise provided or the services that they're.
And how do you do that? You ask for financials, or?
Well, you ask for financials, you just go ahead and tee up. If you're, go ahead and ask for financials. It goes back to the credit assurance. If you're doing a kind of an A to Z analysis of your customers, maybe look at your vendors as well. Ask for financials if you feel like you can, if there's been any rumors or otherwise that you've heard about them, if they're struggling, if you see delays in either their payment to you or their performance under the contracts. And then if they do file and you do have a contract with them, say for the purchase of goods or the providing of services, you're stuck with that contract. We can ask the bankruptcy court to let you out. If they cannot perform under the contract and they're in bankruptcy and you need it and it's critical to you, then you can go in and ask the court to allow you to cancel the contract. You can't do it unilaterally if they're in bankruptcy, but basically the court has to let you cancel that contract unless they can show that they can perform and provide you adequate assurance of performance under that contract. Otherwise, the court should let you out so you can go out and find alternative replacement services or goods or product.
Your comment about paying them and not wanting to double pay kind of ties with the question we just received about preference payments. And I think that has to do with, like, if you're paying or your customer pays you, do you have to pay it back potentially in bankruptcy? Is there things you need to worry about on when you're, I guess, either paying a vendor or getting paid by a customer? Can they grab that money back?
So if you're paying the vendor and the vendor goes into bankruptcy, not worried about it being a preference, because the bigger concern is, did you get what you should have gotten for the payment? Okay. The concern is if you're getting paid by a customer and then the customer goes bankrupt, that's where you have the preference risk. If a debtor makes a payment to a creditor within 90 days of filing bankruptcy, so at any time that you receive a payment from a company that's troubled, that potentially could file bankruptcy, you're at risk of having that payment clawed back. It's called a preference. And it's a hard conversation to have with clients. Wait a minute, they still owe me 25 grand and I have to give another 25 grand back. Yes, you do. Very difficult discussion. However, clients also say, hey, I think this company's troubled. They're going to pay me on a debt. Should I take the payment? I don't want to be sued later. And I always say, yes, always take the money. Why? Because you can always settle. If they do file bankruptcy and there is a trustee appointed, or you get a demand letter in the mail and it was a $100,000 payment, without even looking at it, I can probably settle it for 75, and you keep the 25 in your pocket, and that's money you're keeping. If you had never gotten it in the first place, you never would have gotten it. And then you have defenses, ordinary course of business, subsequent new value, all things a lawyer can work with you on, that you might even be able to get that down even lower just with some phone calls. Now I've got 35, 40, 50 grand in your pocket because that trustee is going to have to spend a lot of money to sue you to get it back. So I always say, take the money and fight about giving it back later. If you're worried about being able to give it back, park it somewhere, park half of it somewhere, but always get the money in your hands.
Okay. That makes a lot of sense. I'm looking at the time, and unfortunately, it kind of played out the way I thought it would, because worrying about customers and vendors is so important to so many of us that we didn't have time to talk about if a company was wanting to go into bankruptcy. And with 1 minute left, I don't think we have that ability. To our attendees, John, I'd love for you to give your contact information out in case they want. Go ahead and do that right now.
Sure. So my name is John Mitchell. Pretty straightforward. My email is john.mitchell@Akerman. It's Akerman, Akerman.com. There's no C in Akerman. Or you can call me on my cell phone these days. I'm stuck at home like everybody else. 214-557-1988. Love to chat with people. And if I can't help you, I certainly could help refer you to somebody that can. And but always enjoy taking the calls.
He's always been very helpful anytime I've had a question. Also be aware that for the last 3 presentations, including this one, we actually have it recorded and we can send you a copy of the recording. The first one we didn't because I wasn't smart enough to figure out how to push the record button. But we do have a transcript on the environmental side of low oil price or the environmental issues associated with low oil price. Otherwise, all the others, we have videos if you want to. And so if you want those, talk to your OTA representative and they'll get that information and we'll get that to you. Looks like we're going to be expanding this program. We're going to take next week off, and then we're going to start with a co-host or co-sponsor that we'll be announcing shortly. And we've got going to continue these webinars with some really good speakers that talk about the industry, but also things that are affecting our business. So stay tuned for your for the invitation and for the additional information for that. If you have any questions, again, don't hesitate to reach out to me or any OTA Chemark representative. And with that, John, thank you very much for your time and input. Very informative. And unfortunately, in today's world, it's going to be very, very important to know that type of information. So with that, I'll leave you and have a great day, everyone.
Thank you, everyone.